Hello dear aspirants, welcome to Epitome IAS. So we are doing the UPSC PYQ analysis. Today's topic would be the continuation of Indian judiciary from the Indian polity. So let us start with the first question. Who was the Chief Justice of India when the public interest litigation PIL was introduced to the Indian judicial system? A. M. Hidayatullah, B. A. M. Ahmadi, C. A. S. Anand, D. P. N. Bhagavati. So if you see in this question, they are talking about the public interest litigation and who was the Chief Justice of India during that time when the PIL was introduced in the Indian system. Okay, so if you see here in the last previous video we were talking about this public interest litigation and those people who are the pioneers of the introduction of PIL in the Indian context. Okay, so one was P.N. Bhagavati. Yes, this is the correct answer, P.N. Bhagavati. And do you remember the another personality who was related to the introduction of PIL? It is V.R. Krishna Iyer. Do you remember this? He was the Justice of Supreme Court, and the question was about whether V.R. Krishna Iyer ever served as a Chief Justice of India. So the answer is no, he never served as a Chief Justice of India. He only served as a Judge of a Supreme Court. Okay, and along with P.N. Bhagavati served as a Chief Justice of India. Okay, along with P.N. Bhagavati, V.R. Krishna Iyer, these two famous personalities, they actually are responsible for introduction of public interest litigation in the Indian context. Okay, this happened around in 1980s. No need to remember the year, just remember these names of two personality. Okay, so the correct answer is option D, P.N. Bhagavati. So if you see here, the public interest litigation was introduced to the Indian judicial system during the tenure of Chief Justice of India, P.N. Bhagavati. Okay, then Bhagavati served as the Chief Justice of India from July 1985 to December 1986. No need to remember these dates and years, but he played a pivotal role in revolutionizing the Indian judiciary by introducing the PIL. Okay, this is what you have to remember. Okay, P.N. Bhagavati and V.R. Krishna Iyer. So first of all, you have to understand, okay, related to this question, what is public interest litigation? This is what you have to remember. Okay, first of all, first let us say there are some group of people. Okay, these people are serving as bonded laborers in any particular area. Just for giving you an example, I'm giving you this condition. Okay, this case, let us say these are some of the group of people who are serving as bonded labor in any particular area. Now these people are very marginalized and they are poor. Okay, so these marginalized section of the society, they don't have awareness. Okay, and they don't have the financial resources or other resources, they don't have influence, right? So in that case, they are not going to, they don't know how to fight, or how to come out of this bonded labor. Okay, they believe that whatever they are going through is it is meant to happen, and they don't know, they don't even have the awareness that this particular bonded labor is wrong. Okay, according to the Constitution of India, it is actually banned. They don't know, and they can't go to the court, and they can't file a case, right, because of the ignorance. Now there is another person who has a public interest. Okay, and this person has some sort of knowledge or financial resources. Okay, now this public interested person can file a case for this bonded labor. Okay, in courts, in Supreme Court or in High Court, he can go and file a case to save these people, even though this particular person is not directly affected by the bonded labor. Usually what happens, if I get affected because of some issue, I go and file cases, okay, or some of my relatives or some of my known person is got affected, then I can go and file a case. Now this person has nothing to do with these people. He's completely a different individual, but still he has a public interest that what is happening is not right. So he goes to the court and files the case on behalf of this poor people, the marginalized section of the people, society. Okay, so these people, they don't have that power, right? So he is helping them out. Okay, now this is known as public interest litigation. So whenever there are many different examples we can say. Okay, one such example is, let us say there is a factory. Okay, it is causing many environmental degradation, environmental pollution, and those people, let us say it is a village, and those people does not have the knowledge or does not have the resources to go to the court and file a case, right? In that case also, another person who has a public interest can file a case on behalf of these people. Okay, let us say some child is um, this child has been harassed or misused or violated. Okay, in that case also, another public minded people, person can go and file a case on behalf of this person, this child. Okay, so these are some of the examples where we can file a public interest litigation on behalf of these people who can't go to the court themselves. Okay, so if you see here, public interest litigation is a legal action initiated in a court of law for the enforcement of public interest or general interest in cases where the violation of constitutional or legal rights. Okay, whenever there is a violation of any constitutional right of people or any legal right of people, but the people does not have the power to go to the court, okay, then any public minded person can come and file a case on behalf of them. Okay, so who are unable to approach the court directly due to poverty, ignorance, or social disadvantage. Sometimes what happens, these people, because they are having some sort of social disadvantage. Okay, if you see, these people are very less influential. They don't know any influential people. Okay, they don't have money power, they don't have muscle power. But if they are going and talking also, okay, these people who are controlling them, they have money power, they have muscle power, they have influence. Okay, they are easily getting you know exploited. Okay, that's why, because of all these reasons, when an individual or when a group of people, they are unable to go to the court directly for themselves, then a public minded person will come and help them out. Okay, it allows any individual or any organization, okay, they can go and bring attention to the matters of public concern, even if they do not directly affected by the particular issue. Even though they are not affected by the issue, still they can go and they can file the case whenever it is a public interest. Okay, then PIL cases are aimed at ensuring justice for the underprivileged and the marginalized sections of the society. Okay, next question. Consider the following statements. Statement 1: the parliament cannot enlarge the jurisdiction of the Supreme Court of India, as its jurisdiction is limited to that conferred by the Constitution. Statement 2: the officers and the servants of the Supreme Court and the High Courts are appointed by the concerned Chief Justice, and the administrative expenses are charged on the Consolidated Fund of India. Okay, this is the question. So in the first statement, what they are saying is, Parliament cannot enlarge the jurisdiction of the Supreme Court of India. So technically, in one of the previous video, I think the last video, we actually saw this provision, right? The jurisdiction of the Supreme Court of India, it can be enlarged by the Parliament of India. The Parliament of India has the power. It is actually given by the Constitution of India directly, okay, to enlarge the jurisdiction of the Supreme Court of India. But here in the question, they are saying Parliament cannot enlarge the jurisdiction of the Supreme Court of India. This is a wrong statement. Okay, and if you see statement 2, The officers and servants of the Supreme Court and High Court are appointed by the Chief Justice. First, let us see this part, first half of the statement. Okay, so the first half of the statement says that officers and servants of Supreme Court and High Court are appointed by the Chief Justice of that particular court. Is that true? Yes, the Chief Justice of High Court or any Supreme Court or Supreme Court, they both have the power for the appointment of the administrative staffs and officers. Okay, so this part of the statement is a correct statement. Now you see the second part of the statement. The administrative expenses are charged on Consolidated Fund of India. Yes, this is also true. The administrative expenses are actually charged on the Consolidated Fund of India. So this statement is a correct statement. The option B, only 2 is the correct answer. This is official answer key. We are actually seeing the official answer key which is given by the UPSC. Okay, so B is the correct answer. Article 138 of the Indian Constitution. Okay, this particular article 138 of Indian Constitution, it provides for the Parliament to extend the jurisdiction of the Supreme Court of India. Okay, so directly this provision is mentioned in the Constitution of India. Okay, and Article 146 of the Constitution of India, it provides for Supreme Court. Okay, and in case of High Court, it is Article 229 of the Constitution of India. These are some of the important articles which you have to remember. Okay, sometimes you have to remember the factual things also. Okay, article number you have to remember this. In case of Supreme Court of India, Article 146, and in case of High Courts of India, that is Article 229. Okay, so both of these articles, they provide for the Chief Justice of that particular court. He has the power to appoint the officers and servants of the particular court. In case of Supreme Court, the Supreme Court's officials and servants, and in case of High Court, that particular High Court's servants. Okay, so also their administrative expenses are indeed charged on the Consolidated Fund of India. Okay, so let us go to the next question. Consider the following statements. There are 25 high courts in India. Statement 2. Punjab, Haryana and Union Territory of Chandigarh have a common high court. Statement 3. National Capital Territory of Delhi has a high court of its own. Now this particular question, you should be able to answer this if you have seen the last video. Okay, try to answer this question yourself first. So if you see here in the first statement, they are saying there are 25 high courts in India. Okay, can you remember how many high courts are there currently in India? It is 25 high courts. Actually, this statement is a correct statement. This question was asked in 2005. Then there was, there was not 25 high courts. Currently, it is 25 high court. So this statement was wrong according to the official answer key of the UPSC, because at that time in 2005 there were no 25 high courts. Currently it is 25 high court. Okay, and because of that, this particular statement is a correct statement in current situation. Okay, we will be seeing current situation to understand this particular things. Okay, if a question is asked in future, exams, you should be able to understand. Okay, 25 high courts we have. Then Punjab, Haryana and Union Territory of Chandigarh have a common high court. This thing also we saw, right? This is correct. Yes, Punjab, Haryana and Chandigarh, they have a common high court. We saw that there are 3 such high courts which are shared by states. What are they? One is obviously the Punjab High Court, which is shared with Haryana and Chandigarh Union Territory. Okay, there is another one, that is what? Guwahati High Court. Tell me what are the states here? It is shared with 4 states. Guwahati High Court, we saw this in previous video. Tell me what are these 4 states. Okay, then another one is, what is that? That is the Bombay High Court. So the Bombay High Court is shared between Maharashtra and Goa. Okay, here these are the 3 cases where the high courts are shared between states. Okay, states and union territories in some cases. But when we talk about the union territories, let us say the high courts which are shared along with the states, along with union territory, there are 6 such high courts which are shared among states and union territory. Okay, we saw these also, these 6. What are these 6? First, these 3 will be there and another 3 will be there. Okay, one is Kerala High Court, Kerala plus Lakshadweep. Then we have Kolkata High Court, that is West Bengal and Andaman and Nicobar. Then we have Madras High Court, that is Tamil Nadu and Puducherry. Okay, these are the 6, high courts which shared by states and union territories. But when they are asking which of the high courts are shared only by the states, okay, here union territory is not considered. In that case, there will be 3. One is Punjab High Court shared by Punjab, Haryana. Then another one is what? Guwahati High Court shared by 4 different states. And we have Bombay High Court shared by Maharashtra and Goa. Okay, so this statement is a correct statement. Then the National Capital Territory of Delhi has a high court of its own. Is that true? Delhi has a high court of its own. Yes, we saw this also in the previous video. Delhi has a own high court. Okay, it does not share its high court with any other states or union territories. And one thing you have to remember is Delhi is the only union territory which has its own high court, which does not share with any other states or union territories. So then there is another one union territory which has a high court for its own, but it shares its high court with another union territory, that is Jammu and Kashmir. So the High Court of Jammu and Kashmir, okay, this is present in Jammu and Kashmir obviously, and the Jammu and Kashmir is a union territory. It has a High Court for its own, okay, but it also shares its High Court with Ladakh. Okay, it is also another union territory. So only 2 union territories have High Court of their own. One is Delhi, another one is Jammu and Kashmir. Okay, and only one high court is present in the union territory of Delhi, and it does not shared with any other states or any other union territory. It is exclusive for the national capital region. Okay, so that is the thing. So if you see here, this statement is a correct statement. What is the correct answer? 1, 2, 3 is the correct answer, but in official answer key you will be getting A, 2 and 3. Why? Because during this time the question was asked in 2005, right? Tab 25 high courts were not there. Tell me what is the latest high court? Okay, what is the latest formed high court? Let me tell you the answer. It is Andhra Pradesh. Okay, High Court of Andhra Pradesh. It was the latest added high court. Okay, now the institution of High Court originated in India in 1862 when the High Courts were set up in Calcutta, Bombay and Madras. So the first High Courts were set up in the 3 presidencies, Calcutta, Bombay and Madras. Okay, in 1862. No need to remember the year. Just remember that it is pre-independence. Okay, and in 1866 what happened? A 4th High Court was set up in Allahabad. Okay, this is the 4th High Court, and currently we have 25 High Courts in the current time in India. Okay, and indeed Punjab, Haryana and Union Territory of Chandigarh, they have a common High Court. Okay, that is the Punjab High Court. Okay, then Delhi is the only union territory that has a High Court of its own, but we can say even Jammu and Kashmir also has a High Court of its own. Okay, so both Delhi and Jammu and Kashmir has a High Court of its own, but only difference is Delhi does not share its High Court with any other union territory or any other state. But in case of Jammu and Kashmir, it is sharing its High Court with Ladakh. Okay, then the Parliament can extend the jurisdiction of a High Court to any union territory or exclude the jurisdiction of a High Court. So who has the power to extend the jurisdiction of the High Courts? Obviously the Parliament has the power. In the last question we were talking about the jurisdiction of the Supreme Court. It is also the power of the Parliament. Just like that, extending the jurisdiction of the High Court over any union territory, okay, or excluding the jurisdiction of a high court. Both comes under the power of a parliament, okay. Then consider the following. Statement 1, disputes with mobile cellular companies. 2, motor accident cases. 3, pension cases. From which of the above are Lok Adalats held? They are simply asking which of these following come under the jurisdiction of the Lok Adalat. Lok Adalat. Okay. So if you see here, first is disputes with mobile cellular companies. Yes, whenever there is a dispute, not all the cases, some cases, there is a dispute between a mobile company and the customer, it can be taken up by the Lok Adalat in some cases, not always. Okay. uh, in majority of the cases, separate redressal mechanism will be provided. Okay. In some cases it will be taken up by the Lok Adalat. Okay. Then the motor accident cases, here also if you see here, earlier this particular motor accident cases, it comes under non-compoundable offense. We actually talked about this non-compoundable offense and compoundable offense in the previous video. What is compoundable offense? Compoundable criminal offense are some criminal offenses which are able to compromise. Let's say two parties are there. Okay, these two parties, they can go compromise and settle the issue. This is not. This is what. This is compoundable offense. Okay, and there is another criminal cases which are non-compoundable offense. What are these? These are the cases which are not able to compromise. It is not possible. Let's say there is a kidnapping happened or a murder happened, then these two parties, they cannot compromise. Even if they compromise, even if they give money to the victim compensation, it is not fair. So he'll be punished according to the law. Okay, so these are non-compoundable offenses. So here, we yesterday talked about this. These Lok Adalats can take up the criminal cases as well as civil cases. In criminal cases, it can only take up the compoundable offenses, compoundable criminal offenses. Okay, it cannot take up the non-compoundable criminal offenses. So technically, this motor accident cases, these comes under the non-compoundable criminal offense. Okay, but what happened is, in Supreme Court judge, in a Supreme Court judgment, the Supreme Court of India said, in some cases, not all the cases, in some cases, these motor accident cases, certain particular cases can be tried by the Lok Adalat. Okay, so in this context we can say yes, the statement 2 is also there. It also comes under the jurisdiction of the Lok Adalat. Okay, then pension cases, yes, whenever there is a issue in the pensions also, it will be under the jurisdiction of the Lok Adalat. So if you see here, all these three, not all the cases, but some of the cases are coming under the jurisdiction of the Lok Adalat. Okay, so the answer would be option D, 1, 2 and 3. Okay, then Lok Adalat or People's Court. So what is the meaning of this word itself? Lok Adalat. Lok Adalat means it is People's Court. Why this particular court, Lok Adalat, is established? To reach the common masses. Okay, the marginalized or the remote areas. People are there, they are not able to go to the court. They don't have financial resources, they don't have that much awareness, and they don't have time also. They don't want to waste 1 year, 2 year, 3 year, every time they have to go and come. They don't want to go through that hideous process. So that's why, to reach the common masses, this particular Lok Adalat has been established. Okay, here what they do, they take this judicial services to the doorsteps of the people. Okay, to the remote areas. This is one of the alternate dispute resolution. Okay, even without going to a court, there are some means of resolving the disputes or issues. These are alternate dispute resolution. Why? There are many reasons. One is high number of pending cases in courts of India. Okay, that much amount of cases are pending, and it is taking a lot of time also for completing one case. Okay, so because of this, these alternate dispute resolution mechanism helps in speedy trial, okay, in speedy justice. Okay, tell me in which article the Constitution of India provides for the speedy justice, speedy trial. I'll give you a clue. It is part of DPSP. Okay, tell me the answer. Let us see who is going to tell the answer. It has the jurisdiction over both civil and criminal cases. This is one of the important point you have to remember. If the statement is formed like the Lok Adalat have the jurisdiction over only the civil cases. No, it is wrong. It has jurisdiction over the civil cases and the criminal cases. But only condition is these criminal cases should be of compoundable criminal offense. It cannot be a non-compoundable criminal offense. Like simple minor petty theft. Okay, petty cases. So these comes under the compoundable criminal offense. Okay, so yeah, see here, civil cases, Lok Adalat can deal with civil cases including motor accident, family disputes and land acquisition cases. These are some of the examples. Just remember this. The disputes can be pending before any court, including the High Court, District Court, or tribunal. So there is another one question it can be formed. What is that? Whatever the case which are taken up by the Lok Adalat, it should be in pre-litigation stage only. Is that true? No, it can be either pre-litigation stage or it can be in litigation stage. What is pre-litigation stage? Pre-litigation stage is this particular case before even reaching the court. Okay, that is pre-litigation stage. What is litigation stage? Litigation stage is any particular case which is already pending in the courts, any court, subordinate court, high court, or any tribunals also. Okay, if it is already pending in any court or tribunal, this is called as litigation stage. And pre-litigation stage is nothing but before going to the court itself. There is a dispute between two people and they have not reached the court itself, then this is called as a pre-litigation stage. So the Lok Adalats can take up both the cases, pre-litigation stage also or litigation stage also. It can take up both the stages, cases in both the stages. Okay, but there is only one condition to take up the cases by the Lok Adalat. What is that? The case is when two parties are agreeing for that. Okay, whenever there is a dispute between two parties and these two parties are agreeing to taking up the case by the Lok Adalat, then this particular case can be taken up by the Lok Adalat, even though it is already pending in any court of law. Okay, then however, cases must be of a civil nature and should be capable of being settled by the way of compromise. Again, not all civil cases come under this. Let us say there is a civil cases which is very legally complicated and it needs the expertise of the courts, either the subordinate courts or the high courts. These cases cannot be taken up by the Lok Adalat. Only those cases which are very simple and there is a way for compromise. Okay, then only these cases can be taken up by the Lok Adalat. Okay, in case of a civil case. And in case of a criminal case, Lok Adalat can also deal with certain criminal cases that are compoundable offenses. Compoundable or simply, in simple word, compromisable. Okay, when there is a, provision for compromise, then only they can take the compoundable criminal offenses. Let us say the criminal case is very, complicated or it is a very serious crime, then it cannot be taken up by the Lok Adalat. And compoundable offenses are those offenses where the parties involved can reach a compromise and the case can be withdrawn with the permission of the court. Let us say there is a case which is already pending in the court. Let us say it is a compoundable criminal offense, then this particular case can be taken up by the Lok Adalat with the permission of the particular court. Let us say it is pending in any subordinate court. Then with the permission of the court, they can take up the case. Okay, then examples: minor offenses such as traffic violation, petty theft, etc. Okay. Then pre-litigation disputes. Now what is pre-litigation disputes? As I already told you, before reaching the court itself, any case before reaching the court, this particular stage is called as a pre-litigation stage. So apart from cases pending in the courts, Lok Adalats can also handle pre-litigation disputes that have not yet been filed in the court. Okay, so this is particularly encouraged to unclog the judicial system and provide speedy resolution of disputes. Okay, already there is a lot of pending cases and the judicial system is already clogged. I can say it is clogged. So one, it is unclogging the thing, and also new, there is no addition of new extra burden to the judiciary. Instead, what they are doing, they are giving a speedy resolution for the disputes. Both the parties are agreeing, and this particular cases are not even going to the courts. Okay, so there is a need for consent of parties. As I already told you, it is so obligatory that both the parties should agree to go to the Lok Adalat. Then only these cases can be taken up by the Lok Adalat. Otherwise, the Lok Adalat does not have the power to take up the cases. Exclusion. Certain categories of cases such as non-compoundable offences, that is like very serious offences which is not able to compromise. Okay, and cases affecting the public interest cannot taken by the Lok Adalat. Okay, then under the Motor Vehicle Act, motor accidents are considered as non-compoundable offences, as I already told you. But what happened is, the Supreme Court of India, it allowed the Lok Adalat to take up the motor accidents also in particular cases, not all cases. Okay, then consider the following statements. Statement 1, the highest criminal court of the district is the court of district and the sessions judge. Statement 2, the district judges are appointed by the governor in consultation with the high court. Statement 3, a person to be eligible for appointment as a district judge should be an advocate or a pleader for 7 years standing or more, or an officer in judicial service of the union or the state. Statement 4, when the sessions judge awards a death sentence, it must be confirmed by the high court before it is carried out. So if you see here in the first statement, they are saying that the highest criminal court of a district, in a district level, the highest criminal court is court of district and the sessions judge. Is that true? Yes, this is correct. Let us say in state level we have high courts, in national level we have Supreme Court. So in district level we have these district courts or the session courts. We can split actually. In district level there will be a civil cases will be handled by different courts, and the criminal cases will be handled by a different court. Okay, so this criminal cases are handled by the session court or the district court, that is the highest court in a district level. Okay, this statement is a correct statement. Then statement 2, the district judges are appointed by the governor in consultation with the high court. Is that true? Yes, whenever there is appointment of the district judges, they are appointed directly by the governor of that particular state in consultation with the particular high court of that state. Okay, now tell me, the high court judges are appointed by whom? Is it governor or is it president? Tell me the correct answer. Okay, so this statement is a correct statement. Then a person to be eligible for appointment as a district judge should be an advocate or a pleader for 7 years. Is that true? Yes, whenever this high court judge, the district judge, whenever there is a appointment for a district judge, what is the eligibility criteria? The eligibility criteria is he should have served as an advocate or a pleader for at least 7 years, or or what he can do, he can be an officer in the judicial service, either union government or state government. Okay, he should be a judicial officer. So these are the two conditions. This is also correct, directly factual. Then when the sessions judge awards a death sentence, it should be confirmed by the high courts before execution. Is that true? Yes. The district high court, the district court, which is the highest court, criminal court in a particular district, it has a power to award a death sentence. Okay, but there is one condition. What is that? Whenever there is award of death sentence, it should be confirmed by the high court. It should be rechecked by the high court before the execution to have to have fairness. Okay, so that any innocent, they cannot be executed in the death sentence, right? So there is a double check here. Okay, so this is also a correct statement. So answer D, 1 2 3 4 is the correct answer. So you can see here on top level we have Supreme Court, okay, national level. Then we have high courts of every state, almost every state. Not every state is having high court, we know that, but almost every state, in state level we are having high courts for the jurisdiction of state, states. Then apart from that we have subordinate courts. Okay, we have subordinate courts or the lower courts, we call them as subordinate courts or the lower courts. So in the subordinate courts we'll be seeing different branches. One is civil, next is criminal, and next is revenue. So these are the three branches. Okay, after that in the district level. Okay, we'll be saying civil courts, we'll be saying criminal courts, and we'll be seeing the revenue courts. Now let us see the civil courts first. So in civil courts, in the district level, we have district judge or a sessions judge, okay, of a civil court. And in another level, if you go down, you will be having sub judge family courts. Then you have munsif. Then you have small causes courts. Okay, this is a local level. Okay, then in criminal courts, you will be having a district level, you will be having sessions judge or the district judge. We can say sessions courts or the district court. Okay, and in local level we will be having metropolitan magistrate or magistrate, class magistrates. Okay, then in revenue court we will be having the board of revenue. In next level we will be having commissioners and the collectors. Okay, you'll be serving one day, right? And in next level, if you go down, tahsildars. Okay, then we have naib tahsildars. Okay, so this is revenue courts. Okay, and this is criminal courts. Now the districts and the sessions judge court presided over by the district judge is the highest court handling criminal cases at the district level. Okay, and it deals with some of the serious offenses carrying punishments like death penalty, life imprisonment, and imprisonment exceeding 10 years. So even the district courts have the power to award death sentence, life imprisonment, or the imprisonments which are exceeding 10 years. These are some of the serious offenses. Okay, but there is only one check, that is whenever this particular district court it is imposing a death penalty, it should be reconsidered by the high court. It should be confirmed by the high court, then only the death penalty will be executed. Okay, this is a provision which is there. Then appointment of district judges. So as we already saw, the governor of the state, of that particular state, he will be appointing the judges of the district court. Okay, with the recommendation of the high court, with the recommendation of the high court of that particular state. Okay, then eligibility. What is the eligibility for becoming a district judge? First, he should be a advocate or a pleader, Okay, a person who has practiced law as an advocate or a pleader for at least 7 years. Okay, remember this, 7 years. Okay, then or else what he can do, or else he can serve as a judicial officer. Okay, as a judicial officer in either union government, that is the central government, or any state government. Okay, so these are some of the eligibility criteria. Then death sentence, as we already talked about it, whenever there is a district or session judge, he imposes a death penalty, it should be confirmed by the high court, okay, of that particular state. Next question. The power to enlarge the jurisdiction of the Supreme Court of India with respect to any matter included in the union list of the legislative powers rests with President of India, Chief Justice of India, Parliament, Union Ministry of Law, Justice and Company Affairs. So we already talk about this in today's video itself. Tell me who has the power to extend the jurisdiction of the Supreme Court of India. Tell me the answer. The answer is Parliament. C. Okay, the Parliament has the power to extend the jurisdiction of the Supreme Court of India. Okay. So the jurisdiction of the Supreme Court of India is defined primarily by the Constitution of India. Okay, majorly it is defined by the Constitution of India under Article 124 to Article 147. And these articles outline the powers, functions, and the jurisdictions of the Supreme Court of India. Okay, the Constitution also gave power to the Parliament. Okay, with the authority to determine and modify the jurisdiction of the Supreme Court through legislation. Okay, the Constitution directly gave the power to the Parliament. The Constitution directly gave the power to the Parliament for extending the jurisdiction or modifying the jurisdiction of the Supreme Court of India. Now, next question. Which one of the following high courts has the territorial jurisdiction over Andaman and Nicobar Island? A. Andhra Pradesh, B. Calcutta, C. Madras, D. Orissa. Just now we saw this particular thing, right? I told you. If you remember, try to answer this question. So the correct answer is the Andaman Nicobar, option B, Calcutta. So the Calcutta High Court has the jurisdiction over West Bengal and the Andaman Nicobar. Okay, so option B is the correct answer. High courts in India. India has a 3-tier court system. Okay, national level Supreme Court, then in state level we have high courts, then we have subordinate courts in district level. So with high courts at the top of each state or union territory, as I already told you, not all states have their own high courts. Still at the state level, even though they are sharing the high courts, at the state level they have the jurisdiction over the states, they have high courts. Okay, and these high courts handle appeals from the lower courts. Now just now we talked about the subordinate courts, these lower courts. So majorly the appeals from the lower courts come to the high court, then the appeal from the high court will be going to the Supreme Court. Okay, so these high courts handle appeals from the lower court and have original jurisdiction in specific cases. We were talking about the original jurisdiction of Supreme Court, right? So even the high courts have original jurisdiction in some of the cases. Okay, so the Calcutta High Court, as we already talked about it, it has the jurisdiction over the West Bengal and the Union Territory of Andaman and Nicobar. Okay, then so that's all for today's class. I'll be seeing you in the next class. Thank you, students.